Okay, hello everybody. Welcome.
Hello.
And welcome everybody at home. My name is Elisa and I work for Erie County Senior Services. I'm part of the University Express team. I want to thank the Cheektowaga Senior Center, especially Dawn, who I know most of you know and do lots of programs with. We are starting up a new program with our technology project here behind me. It's been a lot of work for Dawn and our speakers. Jean also today, which I'm going to do a little introduction on her as well, but she's letting us record this class. So no one in the audience is being filmed, but we have 40 people online from home that are going to be listening to Jean and are able to see her slides as she's talking to you. So it's pretty exciting for older adults that can't get out in the community, don't have transportation, or can't make the classes. If this class was full, so they're able to tune in from home all across Erie County. So we're pretty excited about that. It's brand new for our program. There's 3 centers that are part of our pilot project, Cheektowaga being one. So yeah, so it's pretty exciting. Couple quick announcements. We have a new and improved sign-in system, which I'm not going to elaborate on because Dawn walked around and talked to you all personally on it. We're asking you to register for a little key tag. That will allow you to enter any Erie County Senior Services program at any location. So if you want to do frozen meals with us, if you want to do Stay Fit dining program, if you want to take part in Club 99 Fitness, all of our programs will have the same key tag. So the registration form is just for us. We're keeping your information at Senior Services, not sharing it with anyone. And it takes about 2 to 3 weeks to get your tag in the mail. It's going to make signing in a whole lot easier for us and for you. So thank you for I see a lot of people filling them out. Thank you for doing that. So today we're very excited to have Jean Harris back. She's been presenting with University Express for as long as I've been here, so a while, donating her time, which we are very appreciative of. I'm going to read you a little bit about Jean. Today her class is Basics of Medicaid and Long-Term Care, Protecting and Preserving Assets. Jean Harris is an attorney. She's a partner with Falsgraf, Beinauer, Greer, Harris, Schuler, LLP. For over 18 years, Ms. Harris has focused her practice on protecting the assets of individuals in need of skilled nursing care, either in a facility or at home. In addition, her practice includes estate planning for individuals, including trusts, last wills and testaments, power of attorney, and living will, healthcare proxies, and guardianships. Ms. Harris earned her Juris Doctor, magna cum laude from the State University of New York at Buffalo Law School, and she's admitted to practice law in New York State and in United States District Courts. She's a member of the New York State Bar Association, the Women's Bar Association of Western New York, and the Erie County Bar Association. She frequently lectures on elder law issues concerning Medicaid and payment of long-term care costs, trusts, and estate planning. So I want to welcome Jean to our program today. If anyone, I'll be here after class. If anyone has any questions about registration or senior services, I can talk to you after class too, okay? Welcome and thank you very much for coming today.
Thank you very much. So thank you everybody for being here. I promise that I will get you out as the gentleman requests in time for lunch, which gives me 2 hours. I'm not going to talk to you. So as mentioned, I've come to you from the law firm of Falsgraf, Beinauer, Greer, Harris, and Schuler, but no one expects you to remember that name. So we are colloquially known around town as PB Elder Law, and you may have seen our commercials. We're on TV, we're on the radio. So when you see PB Elder Law, that's actually who we are.
Where are you located?
We're right over by the airport on Cayuga. So we are PB Elder Law. Someone asked me earlier how many attorneys we have. We have 6 attorneys. We have a whole bunch of staff, and we do all things related to elder law, primarily handling estate planning, handling wills, trusts, all that kind of good stuff, and a lot of things that are coming up lately. A lot of the stuff for what the kids call boomers, right? Associated with concerns around care. What happens if somebody needs some level of care. The elephant in the room is usually the nursing home, but it's not always the nursing home. Sometimes we're talking about getting care in our homes. Sometimes we're talking about assisted living care. Goes all the way from somebody kind of just helping us around the house to, God forbid, if there is a need for 24-hour skilled nursing care. I'm going to start today's talk with not diving right into the skilled nursing care, but, well, I'm going to try to start today's talk with, I got a little trouble with the PowerPoint.
Is it not moving?
It's not moving. Oh wait, now I got something kind of.
That was me.
Oh, that was you.
Oh, there you go.
Okay,
Tricky. You have to really hit the button.
okay, I gotta really hit the button, but I'm gonna really hit the button from now on.
Use your muscles.
All right, so I'm gonna start today off. I just wanna give a little bit of a primer on, in my mind, what are the basic legal elder law estate planning documents, because they are essential to any level of elder law or estate planning program, that including Medicaid planning. So we're going to start with the three basic estate planning documents, and those are the durable general power of attorney, living will, healthcare proxy, and a last will and testament. These are the basic things that a person really needs in order to make sure that they are able to take care of any kind of Medicaid planning. So primarily, when we're talking about the three basics, we're first talking about a durable general power of attorney. Durable general power of attorney is, in my view, the most important legal document that a person can have. Everyone should have this regardless of their age. This is not really an elder law document. This is something that everyone needs when they become 18 years old. So my nephew, who becomes 18 years old, on his 18th birthday, he comes to me and he says, you know, thank you for the gift of $100, Aunt Jeannie. And I say, oh, you're welcome, Matthew. Sign this power of attorney. Okay, it's the most exciting gift he got on his birthday. So a durable general power of attorney is the legal document where you are allowing another person to make legal, business, or financial decisions for you if you can't make them for yourself. So God forbid you're in an accident, or there's some sort of catastrophic medical condition where you can't get to the bank, or you can't get to your health insurance company, or you can't make any sort of contract, and there's no one who can make that contract or make that financial decision for you, can't access your bank accounts. If there's no one to make that decision for you and you can't make that for yourself, then there's no one to make that decision for you. No one can do anything for you. So what happens? Then we have to actually petition the New York State Supreme Court to have a guardian appointed for you. And this is a very long and very traumatic process for your family. All of this can be avoided if you have in advance appointed a person of your choosing to be your power of attorney. A power of attorney is a principal-agency relationship. You are the principal. So as long as you have capacity, you are the person in control. You have appointed your agent. So that person can't just run around and do things that you don't want them to do. They must take your direction. They must do what you want them to do. But if you lose capacity, your agent then has the ability to help you, okay? So the power of attorney is really important. It's called a durable power of attorney because it continues even in the event that you lose capacity. It's called a general power of attorney because it can be used anywhere. It's not specific to one specific financial institution. Certain financial institutions, for example, may have a power of attorney. M&T Bank has a power of attorney for M&T Bank. That's great, as long as the only things that have to happen at M&T Bank. But if you have something that has to happen at Key Bank, your M&T Bank power of attorney doesn't do anything. So a general power of attorney works everywhere, okay? So it's important to have a durable general power of attorney. You can appoint one agent, you can appoint multiple agents, you can require that your agents act together so that 2 people or 3 people all must be present, signing the same check, signing the same document, taking care of the same transaction. Or you can say, I have 2 people as my agents and either one of them can act independently of each other. So there's lots of different things that your power of attorney, it can be pretty flexible, but it has to be a durable general power of attorney. It also should contain something that's called a statutory gift rider. This is an allowance for your agent to make transactions using your power of attorney that remove money out of your name and give it to another person or possibly into a trust that are not for fair market value. Allows your agent to take money out of your name, give it to another person, or give it to another entity that are like a gift. Okay, that becomes important sometimes for tax planning, sometimes for Medicaid planning, as we'll see later. Okay, did you have a question?
Yeah, what happens if you regain capacity?
So if you regain capacity, the power of attorney stays the same. If you regain capacity, the power of attorney is still there. It's just that you take over making your own decisions again.
So they don't have power until you lose capacity again.
No, they always have the power. The question is what happens if you lose capacity, but then you regain capacity? They just stop using the power of attorney for a little while, right? When you lose capacity, they step in and they start taking care of your banking for you. When you regain capacity, they step away and they stop using it. So a power of attorney can be used for convenience purposes. You don't have to be incapacitated for them to use it. So for example, my mom went to London to go see the Bills play. God bless her and all that, okay? If she needed something done, she had full capacity. Well, presumably, I don't think she was having that much fun. So let's assume that she had capacity while she was over there, okay? But if she needed me to do something for her, I could have, even though she had capacity, I could have gone to the bank and said, okay, I'll pay your bills for you while you're gone. Okay, she was unavailable. I could have helped her, all right? But she had full capacity. So it doesn't require that you're incapacitated. Does that help?
Yeah.
Okay. Did you have a question?
Do power of attorneys ever expire? Because ours is like 8 years old or something.
A power of attorney does not expire until you revoke it.
Okay.
Okay. If you a power of attorney does not expire during your lifetime unless you revoke it, it does expire naturally upon your death. So a power of attorney is only usable during a person's lifetime. It expires naturally when you pass away. Okay.
What stops a person for draining your bank account if you have power of attorney, but you're still capable?
The law. It's illegal. It's the same thing that stops them from stealing from you now. Okay? So yes.
You have to go to an attorney to get this done.
You don't technically. So and I'm going to take a couple more questions and then I'm going to move on because we do have a lot to cover. Okay. But I will answer. I will say this too. My contact information is on all of these documents and I have cards here. You guys can always email me or call me if you have further questions to follow up. And that applies to anybody who's listening as well. Okay. The power of attorney forms is something that you can find. I don't recommend that you do this without the guidance of an attorney, just like I don't recommend that you do a last will and testament or any other legal document. The reason why I don't recommend that is because there are very specific rules for the execution of the power of attorney and the formal requirements of a power of attorney. You wouldn't believe this, but truly, I would say probably 70% of the time, even powers of attorney that come to my desk that are prepared by other attorneys, if they are not done by elder law attorneys, people who really focus their area of practice in elder law, are done inappropriately. They don't actually give the authority that they should. And that's because they are really specific. The law is really specific about how they need to be executed, where they need to be initialed, where they need to be signed. And the law is really specific even about the type of font that has to be used in a power of attorney in order to give the appropriate authority. Specifically, the statutory gift rider that has to be executed on the power of attorney to make it, to give it the specific authorities that it has to have in order to help you, really are highly specified. And so if it's done incorrectly, what it usually does is gives a person, they think that they've done it correctly. It gives you like this false sense of security. And so you think, okay, well, I did my power of attorney. It's all set. I'm good to go. But then when you go to use it, it's actually not done correctly. They're not expensive to do. They're not, when they're done correctly, you're in really good shape. But it makes sense to have it done by an attorney, just like a will. Okay, it's not the kind of thing that you do generally. You should be doing at home. Yeah.
Could you just give like a range of what it might cost?
So
just like a general.
This is the question, and this is going to come up over and over today. I'm going to be asked, how much does it cost to do X, Y, or Z? And I'm not going to answer that question for anyone. Okay, and it's gonna frustrate you guys and you're gonna think like I'm leading you on, but I'm not. It's the same kind of thing, like you take your car, you call up a car mechanic and you say, well, my car is making this noise. Can you tell me how much it's gonna cost to fix it? The car mechanic isn't gonna be able to give you that cost because they're gonna say, well, I need to look at it first, right? And it's the same thing for everyone here. I cannot give you a baseline until I see what you have, because I don't know. It's a highly specific for everybody here. And until I actually look at what you've got and know specifically what it would take for you, I can't give you a price. Moving along. So the power of attorney, that's number one. Okay, this is why I could talk for 6 hours with this stuff. Okay. The next document that is a very important document is your living will healthcare proxy. You get this back over. Healthcare proxy living. Okay, let's go. All right. We do your healthcare proxy. We really have healthcare proxy living wills. You guys have seen these every time you go to a doctor lately, or certainly if you've been in a hospital. They are always giving you healthcare proxy forms now, right? A healthcare proxy living will, these are really two documents kind of rolled up into one. A healthcare proxy is what it sounds like. It's proxy. You're appointing a person. You are the principal. They are your proxy. This is you appoint a person, an individual, to make healthcare decisions for you. A living will, not to be confused with a last will and testament, okay? Not also to be confused with a living trust, but a living will is where you are giving your proxy some direction. So you got the proxy is the person and the living will is the direction, some direction on what you would want that person to do. Again, if God forbid, they had to make some manner of end of life decision making for you. So this is where we, essentially, like mine specifically says, I don't want to be kept alive by artificial means if there was no reasonable chance of my recovery. 99% of the time, that's what most people say, okay? Sometimes people have like religious objection to that, but most of the time, we all pretty much agree that that's what we would want. There are other things that are contained inside a living will that are very important that are not contained in the living wills or healthcare proxies that you get in the hospital. Specifically, organ donation clauses, HIPAA releases are usually separate. It's important to have a HIPAA release because if you're asking somebody to make an end of life decision or a healthcare related decision for you, it would be important if they had access to the medical records so that they knew what they were agreeing to, right? That kind of helps. That makes sense, I think. It is important, in my view, to have a healthcare proxy living will that you have considered outside of an extreme situation like one that you're facing when you're in the hospital. And oftentimes when you go into the hospital, they're given this form amongst a pile of other paperwork and you're signing it at that moment. And that may be fine, but anything that you're signing in the hospital often will supersede anything that you've done with your attorney or in another environment where you may have had a little bit more time to consider your options. So I think it's important to have this when you're, kind of calm and settled and not in an urgent situation. So I do think it's important to do the healthcare proxy as well. There is a form that some of you may be familiar with that's called a MOLST form. It's this bright pink form that many people will tell you to do. It's medical orders for life-sustaining treatment. It's basically a do not resuscitate form. Sometimes, and it used to happen around 10 years ago, people would tell you to fill out this form and put it on your refrigerator. It is a hard and fast do not resuscitate form. I would like you to, if you have done that and put it on your refrigerator, I would like you to look at that again and reconsider whether you actually want that, okay? Take a look at it because it is a hard and fast do not resuscitate form. So if at home, on your fridge, or anywhere else, you have a bright pink form, it usually includes something like, do not resuscitate under any means, for any reason whatsoever. Do not also administer antibiotics for any reason whatsoever. And think about that. Think about whether that's something you actually want. So that's usually something that is reserved for end of life measures. And sometimes that is what we want. okay? But sometimes it isn't, so just consider that.
Don't the EMTs ignore that?
They don't ignore that.
So if they run over to look on your refrigerator?
If they find a most form, they will adhere to the most form. So,
Oh, how does, the 5 wishes tie in with this stuff?
your 5 wishes.
The 5 wishes program? It's a form that you fill out?
I don't know the 5 wishes program. What, I don't, yeah.
Yeah.
I'm sorry, does anybody,
It's
do you guys know what the 5 wishes program is?
All living well.
Okay.
But, yeah, okay.
I'm sorry, yeah, the 5, I don't know what the 5 wishes program is, it's not a legal document.
I can get you a copy of it. It's something through the aging mastery program that they're recommending,
Okay,
but it's very similar to like a living will, but I can. so
Okay.
that you-
I don't know what the 5 wishes program is, if you guys are learning about it, I can tell you that it's not a legal document. So I don't know what that is.
It's throughout states.
Okay,
I had family go to California and they have it there. They have it in Arizona. It's a form and at the end of it, it's a booklet and you get it notarized.
okay,
This explains what you want done if you die, what you want done before you die.
okay. So is it like a funeral type thing?
It's got all that in there. It recommends, doing that instead of the living will. Filling out that form instead of living will.
I mean, yeah, I don't know about that. It's not, I can tell you it's not a New York State law, particularly if getting something notarized, we're getting a little off track, but getting something notarized, all a notary is acknowledging that you are the person who signed a document. That's all that is.
And this document, it says what you want done. Like if you're in the hospital,
Mhm.
do you want to be resuscitated? Do you want, if you pass, what you want done? How you want your funeral? Do you want your body donated?
Okay, so that would be an afterlife. So, and whether or not you want to be, whether or not you would want somebody to, it sounds like a living will. It sounds like it's got some components of a living will,
Yeah, it has.
but it also sounds like it's got funeral directives in it. It does not sound like it is a living will, but it sounds like it has some components of it.
It touches on 5 different aspects of getting older and passing away.
Okay, yeah, so I don't, it isn't a living will, so I'm gonna get back to what a living will is,
Okay.
if that's okay. So this is what a living will is, which is what I recommend, so I don't know about the 5 wishes. So I do recommend that you have a living will healthcare proxy. I don't necessarily recommend that you have a most form unless I think you have a specific reason to have one. My dad was in a palliative care situation. He did have a most form. I thought it was appropriate for him to have one. So I'm not necessarily recommending that you don't have a most form. I just don't think that they're appropriate for everyone to have. I guess that's all I'm kind of saying about that. Okay. I'm trying. I'm trying, guys.
Something, your light was up on the ceiling, so you might give, I think it down, yeah, it's not the top,
Am I?
That's on your
No, it's
there.
down.
No, well, I pointed at the laptop, right?
We need to do better.
Oh.
This right? That's right?
I think so, yeah, here, let me
Yeah,
just
that's
use that.
that's fine.
I can do it. I can
No,
send
no,
you.
no. Can I not do the buzzy, like? this? Okay. No, no. Yeah, it's easier for me if I just. Thank you. All right. Okay, so we're gonna get, now we've got the will, so, and we are getting to the Medicaid. Alright. Last wills and testaments, so, then we get through our last will and testaments, which is oftentimes, people come into my office and, Gene, I need a will, right? This is one of the documents everybody kind of feels like is one of the most important documents. to me, it's not really one of the most important documents, mostly because I'm far more concerned about what happens to you while you are alive than I am worried about what happens to you after you have died, or what happens to your stuff after you have died, okay? Your last will and testament, though, is the document everyone knows that distributes and is your stuff to your beneficiaries, provides for the distribution of your stuff to your beneficiaries after you have passed away, okay? What I think many people don't really realize is that your last will and testament only provides for the distribution of your assets that are in your sole name, that do not have a joint owner, and do not have a beneficiary. Okay? So if you have an asset that has a joint owner or has a beneficiary, then that asset, it doesn't matter what your will says. Okay? So if you and I share a bank account and I pass away, then that bank account just automatically becomes yours. So it doesn't matter what my will says. Similarly, if I have a life insurance policy, yeah, he smiles, and that life insurance policy names you as my beneficiary, and my will says everything goes to the SPCA, well, the SPCA doesn't get anything because the life insurance policy just goes to you, okay? The process of probate is the process by which we give effect to a person's last will and testament, okay? Sometimes people think that if we have a will, that's how we avoid probate. But that is not true. It took me probably 10 years of practice to realize that many people know that probate is a thing, and they know that it is a bad thing, but they have no idea what it really is, right? And people all throughout the room are shaking their heads like, yeah, I know it's bad. I think it might have to do with taxes, but I don't really know what it actually is, right? So probate is how we give effect to a person's will. So essentially, if I pass away and I have an asset that is in my sole name, like my house, for example, is in my name only, then when I die, we look at my house and it's in the name of Jean Harris only, then we look at the house and we can't tell by looking at it where I wanted it to go. It doesn't say. So we have to look at my will, and my will is what says, oh, okay, Jean said in her will that she wanted it to go to these individual people. All right, but the will is just a piece of paper, all right? And the will has actually no power until the court gives it some power. Because I could make another will tomorrow, and the day after that, and the day after that. So the court has to verify that this is in fact the very last one, that I didn't do it under any duress, that it was done appropriately, that it was overseen by an attorney, that it was done, yeah, go ahead. Yeah, that it was done appropriately, that it wasn't done as a trick, that I knew what I was doing, that I had capacity while I did it, all that stuff. And that's the process known as probate. So the process of probate, just like any other legal proceeding, takes a really long time. And anytime you have something that takes a long time and you have a lawyer involved, that means it's going to be really expensive. So whenever we have a probate, even a probate that is simple, that there are no objections, you can anticipate that the process is usually going to be about 1.5 years or 2 years long. Some parts of that are because the court moves slowly. Some parts of that are because the process requires, for example, when the person who is appointed as the executor is appointed, the court requires a waiting period of 7 months in order to allow any creditors to come forward and put a claim against the estate. So there are laws that require a waiting period of a length of time. Sometimes it's because there are going to be delays associated with just administration. Hi, I wasn't trying to lock. That was locked. It's locked. Tough time.
I know, sorry.
That's okay.
I didn't even know the door was.
So sometimes it's because the banks take a long time. There's administrative, bureaucratic issues, all that kind of stuff. Okay, so probate takes a long time, and because of that, it's an expensive proceeding. Okay, so we want to avoid that. So one of the ways that we avoid having to deal with probate is we make sure that we have a person's beneficiaries named appropriately on their assets. Another way that we can avoid probate is we can make sure that we have a joint ownership listed on assets. We can also utilize trusts to make sure that we have taken a person's assets out of their individual names and placed them into trust, so that when we do that, we're taking it out of a person's individual name, creating a trust, placing an asset into a trust, and therefore, when the person passes away, we know that that individual didn't have anything in their sole name because it's in a trust. Okay, any questions about that? It looks like there might be. Do you have a question? Okay, no? Okay.
What happens if our parents have absolutely none of these documents and they pass away?
Okay,
I
so,
mean, my mother was still living, my father passed away, and they had none of these documents whatsoever.
okay. So if they passed away and had none of them, and they didn't have any need for a power of attorney or a healthcare proxy, then if they had full capacity, they didn't have any need for them, then God was on your side while they were alive, okay? If they had no will and they had beneficiaries or each other listed on their assets, then they wouldn't need a will because they had beneficiaries
They had
listed.
nothing.
If they had, if you have no will, then there is something called intestacy. So if you have no will, the law presumes to know who you wanted your beneficiaries to be, okay? So sometimes people think if you have no will, that your assets just automatically pass to the state. That is not actually true. The law presumes to know who your beneficiaries should be. So if you have a spouse and children, the law presumes you wanted your assets to go to your spouse and children. If you have no spouse, then just to your children. If you have no children, then to your grandchildren. If you have no issue or heirs, then everything you have will go to your parents. If you have no parents, then to your siblings. If you have no siblings, then to your nieces and nephews. And it kind of keeps going up and over down your family tree like that until you are an orphan truly in every sense of the word. You have absolutely no family. And only until that happens does your property escheat to the state, okay? But you have to be truly without any bloodline whatsoever. So that's what will happen. Go ahead.
So if you have an IRA and your spouse is listed as beneficiary, and then your child is listed as secondary beneficiary, and say me and my spouse both die in an accident, my child doesn't have to go through probate to get the IRA money?
That's right. That's right. So one thing that a trust can do that would not naturally happen in the event by making sure that you had just simple beneficiaries listed, a trust would protect in the event that you had minor beneficiaries potentially. So let's say, like in my case, I could name my children as beneficiaries on my retirement account or my assets, but my kids are minors. And that wouldn't make sense for my kids, right? Because my kids are 17 and 15, and they're not legally allowed to hold any money. So that's no good for my kids. Or if you have a family, or like your grandchildren, for example, would be minors. So it's not good for your grandkids to hold any money. Because if, God forbid, one of your kids passes away and that means your grandchildren receive money, they're not allowed to hold any money. So any money that they actually receive is either going to be held by your in-law, or by potentially by someone in the court, in my case. So the court would appoint someone, which is obviously not going to be a person of my choosing. It's going to be some lawyer that the court picks, which is no good, right? The other potential thing that could happen is if there's somebody in the family who has a disability, the receipt of money by somebody who is receiving Social Security, disability, or Medicaid, or supplemental security income, somebody with a developmental disability, can actually be devastating to them because it prevents them from receiving the government benefits that they rely on for survival. So the old-fashioned way would be, if somebody has Down syndrome or some other manner of developmental disability, they would be actually disinherited by their family because it would actually hurt them to receive an inheritance. So now we can utilize certain types of trust to make sure they still get their inheritance and it doesn't actually disrupt any other government benefits that they're receiving. Here's another scary thing about probate. This one is going to knock your socks off because nobody knows this, and it is scary. If an estate goes through probate, if we don't have assets in trust, if we don't have assets passing by other non-probate means, something goes through probate, it's a matter of public record. There's a record room in the surrogate court, and there's computers there, and there's staff. and their job is to help you use these computers. You can go down there for fun if you want, okay, and type in your neighbor's name, and up comes their file, anybody that you know that has passed away, and you can see their will, what it says. Anybody who's passed away, you can't see this for people who are alive, okay? When they passed away, how much money their estate had, who it went to, when it went to them, where they live, when they got it, okay? All of this information is public record. How you like that?
Only if it's gone through probate.
So if it's gone through probate.
So how did you say you looked that up again? You just go to.
There's a room, there's a record room in the court.
Record room?
And there's like little bank of computers down there. Nuts, right? So it's a matter of public record, and all that information is available to you. Look at her nudging her buddy. They're like making plans for tomorrow. She did. They're like penciling it in. But really, like that's in this day and age, isn't that crazy? So I don't like that, right? And so when you utilize a trust, that's a completely private thing within your family. So not only are you getting rid of this entire time delay, the expense associated with the attorney's fees, which typically is about 5% of the overall value of an estate. So that's big money, okay? Attorneys love probate. But you get rid of all that, but you're also preserving significant privacy for your family. I mean, you don't want all that information out there in this day and age. You really don't. So it's a pretty scary thing. So we want to have a will there just in case, okay, it's there. We want to make sure that we have provisions, but we want to avoid having to use it. We want to make sure.
So in his case, did that have to go through probate?
Oh, yeah, my father never believed on any paperwork. He passed
Yeah.
away. My mother was alive. All three children were in their very early to mid-20s.
When there is an administration is what it's called. It's not called a probate anymore. When you don't have a will, it's called an administration. So it's the same process as a probate. It's just not called probate. It's called an administration.
Yeah.
The appointment of an agent to control the disposition of your remains is what you're talking about in that 5 wishes thing. When you're talking about putting somebody in charge of your funeral directive, this is one of those. So you can do this. We will do this form for folks. It's really just letting somebody know what you want done as far as your funeral is concerned. Rather than that, I typically recommend pre-planning your funeral and prepaying for it. I have done that for myself already. I think it makes sense to do. Primarily, it is something that takes a huge headache away from your family members. But also, if you look at it right, it could be a pretty macabre and kind of funny afternoon, depending on how twisted.
No, it could be a very expensive one.
It's an expensive one, but it's something your family's gonna have to pay for anyway.
Well, no, because most of your undertakers, especially on a spouse, they benefit off emotions. Why would you want a $5,000 casket for your spouse when you can have a $10,000 casket for your spouse?
Well, I think you're banking on the people that have been married that long still really love their spouse, though.
Yeah, but don't you?
All the wives laugh.
But don't the surviving spouse need that extra money to live on the rest of their
I
life?
don't know. If I was you two, ma'am, I think you should go now and pick out what you want.
I'm being cremated. I already having this.
That's a good girl. Okay, what can I?
Just a quick, what are they considering legal age, 18 or 21?
That's a great question. It actually depends on who you are. 18. 18. Yeah, okay, 18.
Okay, I have when my dad passed away, he passed away at 69 and my mom, so we decided to go to the funeral parlor and set up our funeral expenses, and so we didn't have to pay, we could put it in supposedly some kind of a trust for the funeral expenses. She was only 69 at the time, so we went to the funeral parlor, paid our funeral parlor, we picked out her casket, we picked out everything that we wanted. And I didn't realize that when you do that, your money gets interest. She lived till she was 91. So by the time she passed away, that amount was much more than the funeral was actually gonna cost. We had to spend that money on funeral expenses. We
Right.
could not use it for anything else.
Right.
And I was really shocked.
Yeah, yeah. I mean, they should have, given her young age, they should have counseled you to spend much less than that.
Yeah, I didn't realize, and like I said, I didn't realize that there was an account that would draw interest. And like I said, I didn't think she lived till she was 90.
Right, yeah, no, yeah,
So there were thousands of dollars
yeah,
in the
no, I
account
agree. Yeah,
that we had to spend.
yeah, I agree, I agree.
Have a big one.
Question?
Can I just quickly respond to that? We did the same thing, and the difference for us was it was revocable as opposed to non-revocable.
Right,
So if it was a revocable one where if your parent had to go on Medicaid or any kind of, then we couldn't get the money back. But if it was just interest, we got money back from the funeral director.
It must have been an irrevocable.
If it was irrevocable, then the government just makes them spend it on the funeral.
It must have been an
But ours
irrevocable.
was revocable and got the money back.
Yeah, I didn't know the difference at that time, what was
Right.
revocable or non-revocable.
What was good about it is the price when we went to put it in, that interest then covered all the rising costs in the funeral. So we
Yeah,
didn't have to pay
yeah.
anything.
all right, well, okay, so we're getting a little off track for our topic, but we're gonna jump into, I moved a few pages ahead because we need to speed up and start actually talking about what we're here to talk about today, which is Medicaid, okay? So when we're talking about Medicaid, we're talking about, it's important to remember we're talking about Medicaid, okay? So we're talking about, there's many different types of Medicaid, but we're talking today about Medicaid and we're talking about skilled nursing Medicaid, okay? Medicaid, there are Medicaid care programs at home. There's Medicaid programs in a skilled nursing facility. We do all types of Medicaid. There's also Medicaid that serves to function like health insurance. Medicaid services at home are, when we're talking about Medicaid at home, we're talking about, we used to be able to get 24-hour care Medicaid for people at home, Medicaid covered services for people at home. We still can get Medicaid covered services for people at home. And when we're doing that, we're really not talking about 24 hours a day anymore, unfortunately. Typically, when we're talking about community Medicaid or Medicaid at home, we're talking about Medicaid maybe 7 hours a day, but not usually 24 hours a day, okay? Medicaid care at home, we're not concerned with a 5-year look back period. Is everybody familiar with the concept of a 5-year look back period?
Yeah.
Okay,
It used to be too.
yeah, it used to be too. When we're talking about Medicaid in a nursing facility, we have to discuss the 5-year look back period. To be clear, there is no 7-year look back period. Somebody is out there in the world around us here in Western New York, talking about a 7-year look back period. There is no 7-year look back period. There is no legislation on the books or being proposed in New York for a 7-year look back period. I am on the elder law committee with the New York State Bar Association, and no one is proposing that. So that is a myth. So don't worry about a 7-year look back period. Okay. It's not happening right now. 5-year look back period. What happens when you apply for Medicaid? In order to apply for Medicaid, you must be in a nursing home already. You can't get ready and you have to be there already. Okay. So you have to be in a nursing facility. You have to be under $30,182 if you are the applicant, okay, the person who's going to need the application. And when you apply, you make your application. That application goes to a county employee, and that person literally looks through all of your bank accounts, every statement by statement, for all accounts that you have had over the course of the last 5 years. Whether those accounts are opened or closed, whether those accounts are with just in your name or with another person, to look and see whether you have given any money away over the course of the last 5 years. If you have given any money away or any big sums of money have gone out of your account or come into your accounts, and they consider in Erie County anything over or under or over $2,000, anything has gone in or come out that is over $2,000, then they want to know where that money has come from or gone to. The $2,000 threshold is not a hard and fast rule. Sometimes I don't even like to tell you the $2,000 number, because then I get people wanting to be crafty and they say, well, it wasn't 2,000, it was 1,998. So it doesn't count. But it does count because it's a human being who's looking, okay? So if that human being can put together, when they're looking at all of your statements and they say, okay, well, it wasn't 2,000, but it was 4 times you did 500, or it was something that looked suspicious because we saw you do 300 multiple times, or it was $50 every single day, or whatever. They'll put it together and they'll see it, okay? So anytime they see suspicious transfers coming in or out, they want to know where that's come or gone. And essentially what the county's position is not really that unreasonable if you think about it, okay? The county is saying, we will come and we will pay your bill in the nursing home as long as you don't have the means to pay it yourself. And if you're saying that you don't have the means to pay for it for yourself, but the only reason you don't have the means to pay for yourself is because you gave all your money to someone else, then we're not going to cover that either. It's not that unreasonable, right? What's unreasonable is the fact that a nursing home costs $20,000 a month. That's what's unreasonable, right? That's the nuts part about this, really. If you have made transfers within 5 years of going into a nursing home, and the transfers were made for the purpose of qualifying for Medicaid, then the transfers are penalized. And the penalty isn't in an amount of money. The penalty is an amount of time that is commensurate with the amount of money that you gave away. So what does that really mean? So roughly for every $12,000 that you've given away, Medicaid says we're not going to cover 1 month of care. So if you've given 12,000, it's 1 month. If you've given 100,000, it's 8.5 months. So what happens? So I've given $100,000 away within the last 5 years, and now I have less than $30,182 in my name, and I need Medicaid. I'm in a nursing home, and I applied for Medicaid, and it's October 18th. Medicaid runs month to month, so I apply for Medicaid, and I want Medicaid beginning on November 1st. Medicaid is going to say, okay, well, we see that you should qualify for Medicaid on November 1st, but since you gave that money away, you are not going to qualify for Medicaid until July. So what happens? Now I'm in the nursing home. I have no money to pay the bill, but the nursing home can't kick me out because that's illegal. The nursing home can't kick somebody out based on the basis of failure to pay, because that's nursing home dumping, and they can't remove you. That's not a safe discharge. They can't, right? That's illegal. So what does the nursing home do? Because now they got to pay for me. They got to take care of me. So the nursing home is like, what happened to Jean's money? Maybe she gave it to Luke, her son. Oh, Luke seems to have some money over there. I think I'm going to sue him. That's what happens. Now they sue Luke. Okay? They look to see who is my power of attorney. Where did I give my money? Now they're going to sue it. Now everybody's into panic. That's what happens. Okay? So and also what it will likely happen is at some point I will have to go to the hospital. And though the facility can't kick me out, they don't have to take me back. So once I go to the hospital, all bets are off. So I go to ECMC, and maybe I was at Elderwood and I was enjoying a lovely time at Elderwood, but now I'm at the hospital and I need to be discharged to a different facility, and maybe I don't end up back at Elderwood. I end up at maybe some not so great facility that isn't where I wanted to go. That's what happens with the penalty, okay? There are ways, obviously, if we can, what we want to do is utilize advanced planning. The goal here, I'm looking around, with the exception of 1 or 2 of you, I think everybody here is gonna make it through the next 5, that was a joke. Everybody's gonna make it through 5 years, okay? But if we can get through 5 years, then we've got no problem. And if I had the crystal ball, we would have no problem, right? So obviously the goal is we can utilize what's called an irrevocable income only trust. And if we can do that, we can take our assets and we can utilize this irrevocable income only trust. We can place our assets, our home, anything that we're not using into this irrevocable income only trust. You are the grantor of the irrevocable income only trust. You can place your assets into the irrevocable income only trust. You get any income as it implies that's being generated from the trust throughout the duration of your life. You can name any person or persons that you trust, like your children, as the trustees of the trust. You maintain the ability to switch out the beneficiaries of the trust or the trustees of the trust during your lifetime, okay? Through the trustees, you can have access to the corpus or the principal of the trust during your lifetime. You don't have independent access to the principal during your lifetime, but you have access to it. When you pass away, the principal of the trust is distributed to your beneficiaries, okay, the way you want it to, outside of probate, because it's in a trust, so it avoids probate. After the passage of 5 years, anything that's in the trust is 100% off the table for Medicaid, so Medicaid cannot touch it, but the trustees have access to it. So if you needed it to enhance the quality of your care throughout your lifetime, they still have access to it, okay? But we've protected 100% of it for Medicaid purposes. That would be
So-
wonderful if we make sure we have the 5 years.
So if you go into the nursing home, then you're covered.
You're covered. Medicaid can't touch it.
Okay, could you give me that name again?
It's an irrevocable income only trust.
And what about the 5 years?
As long as we get through a 5-year period, Medicaid can't touch it.
Otherwise, they can take it from there too?
No, I'll get into what happens if we don't get through. I know this is the next question. I'll get through.
Irrevocable income trust.
Irrevocable income only trust.
Write that down.
Okay. Yes.
That includes signing a home.
One that is,
Trust?
Yes.
I'm sorry, I can't hear you because
Does that include 5 years signing your home over to your children?
does that include the 5 years? I don't understand the question. I'm sorry.
Okay, we signed our home over to our children.
Mhm.
We were told at the time that after 5 years, Medicaid can't touch it.
Okay, so when you say, I know what you mean, but I'm a lawyer, so I'm gonna pick it apart a little bit, but it's not personal, okay? The answer is yes, you're fine. But now I'm gonna pick it apart a little bit because I am who I am, okay? But I love you. So the question is, if we signed our house over to our kids and we've gotten through 5 years, are we okay? The answer is yes, you're okay. But I'm picking that apart a little bit because I think what you have done is what's called a deed transfer with retained life use. You have actually not signed your house over to your kids, okay? You just are saying that, but that's not what you did. A deed transfer with retained life use is something that many people do. And what you actually have done is you've retained ownership of your home through the duration of your lifetime. And you've named your kids as what we call remainder men on your deed. You've named your kids as beneficiary, okay? And so you've retained ownership and control of your home through the duration of your lifetime. I see that you're a veteran, sir, thank you. So that's how you have kept your STAR exemption and your enhanced veterans exemption on your house, right?
Yes.
And so without retaining life estate, you would not have been able to keep that veterans exemption. So that's how I know that you did a life estate. I'm like Columbo like that. I'm putting all these pieces together, okay? So you have the deed is still in your name, but the kids are on as remainder men. So because you have that type of deed, your house is preserved as long as it's been through the 5 years. That's one option. And it's a good thing to do as long as the only thing you were concerned about protecting was your home. Okay, so it is one option. If the house is the only thing that we're worried about protecting, then that's one way to go. One good thing about the trust is that it protects not only the house, but any other assets as well. Okay?
Can I just,
Yeah.
okay, so if you're talking about life estate, does it actually mean that you have to stay in that house until you pass away for them to do that? Or if in turn, say during the course of time, something happens to you and you have to go into a facility or whatever, does that still go to the children completely? Or do they figure that out by percentage, or is it just, how do they do that?
The answer to your question is yes. So, if one of the problems with the life estate is that you must remain, the house cannot be sold during your lifetime. If the house is sold during your lifetime, a percentage of the home will go to the Department of Social Services if you're on Medicaid. If the house is in a trust, the house can be sold and the proceeds from the sale will go into the trust and it's 100% protected.
Okay, but say everything's okay and you decide to just go into an assisted living and you wanna sell your house.
Yeah.
So what happens in that situation?
Portion of the proceeds go to you and a portion of the proceeds go to the kids.
Portion of that goes where? I'm sorry.
To the kids and a portion of it goes to you.
Oh, that's how that does work like that.
Yeah,
Okay.
yeah.
The only time they get the full capacity of the house is if you pass away.
Yes, if it's in a life estate deed, but if it's in a trust,
Right.
the whole thing goes to the trust. Yeah. So if you go into a nursing facility and you need Medicaid, forget the trust and life estate deed and all that. Let's just talk straight Medicaid here, okay? If you go into a nursing facility and you are the institutionalized spouse and you need Medicaid, these are the things that you're allowed to keep. You're allowed to keep $30,182. A car if it's needed for medical purposes. Think wheelchair van, think specialized transportation. Life insurance with a combined face value of $1,500 or less. An irrevocable funeral trust account, prepaid burial account for burial space items for your immediate family members. This is one that's often not used, but I think I try to get my clients to use it more often because these are expensive things. That you can use for your immediate family members, your parents, your kids, your siblings, the spouses of those people. And this is like the tangible physical stuff associated with a burial, and it's expensive. So you might as well take care of that for your kids. Something that seems to surprise a lot of people, you're allowed to keep your retirement assets. They're not attachable by Medicaid as long as you're receiving your required minimum distributions, which you have to take this year at 73 years old anyway. So the principal amount of your retirement accounts are exempt from Medicaid as long as you're receiving your required minimum distributions. And then of course, you get to keep your whopping $50 a month of income plus the cost of any health insurance premiums. So that's what you are permitted to receive. And then of course your community spouse. So you've got the individual in this facility and then the spouse who's living at home. Your community spouse who's living at home is able to keep $74,820 of resources, or 1/2 of your combined assets up to $148,620, whichever is greater. Your residence up to $1,033,000 of equity, which here would be like Josh Allen's house, but you can imagine downstate isn't that hard to come by, right? So it's the same amount throughout New York State. A vehicle of any value, so you could be driving a Bentley if that's what you want, anything you want is fine. But oftentimes I am counseling my clients to get rid of the 9-year-old Buick that has 12,000 miles on it, maybe upgrade to a nice 4-wheel drive Subaru that is going to be a little safer in the snow, right? Again, the funeral accounts, again, the retirement accounts, and $3,715.50 of the couple's combined income. And if the community spouse has additional income, they have to contribute 25% of their overage of income to the institutionalized spouse. So oftentimes, it's not as bad as you think it's gonna be, okay? It could be worse, really. But if you've got a situation where there's significantly more than that, then we have to, there's certainly things that we can do. We work on, of course, the spend down of things, right? There are improvements. If we have a community spouse, we want to look at making improvements to that spouse's home. Again, because we often have a lot of room in equity. There are improvements that we need to make to the house. Roofs that need to be put on, driveways that need repair, things like that that we need to do because it's very uncommon for us to have a house worth $1 million in this area. There's things that need to be purchased, therapies that need to be done for the spouse typically who's in the facility. And then if we have additional money that needs to be sort of spent down, that's one of the things that we work to do with our clients as well. When we look at community Medicaid, there are similar resource and income restrictions for care in the facilities, in the assisted living and in the facilities. I'm not gonna get too far into the burial expenses because I think you guys pretty much know about that. In the materials, you'll see we have listings for what constitutes an allowable burial expense. Yes, ma'am?
The last, when you were speaking before, it says in here $1,500 or less in life insurance. That's all you're allowed to have?
Yes. If you have, I'm sorry, go ahead.
In other words, they say you had $100,000 in life insurance. Medicaid would take balance?
So Medicaid, so let me address that. If you have a life insurance policy that has a high face value, Medicaid considers the cash value of the policy to be part of your resources. So Medicaid, and people come into my office very often and they say, is Medicaid gonna take that? Is Medicaid gonna take my house? Is Medicaid gonna take my life insurance? Are they gonna take what's in my bank account? Medicaid never comes and takes anything. That's not how it works. Medicaid doesn't take anything from you. What they do is they require you to spend your money on your care before they extend coverage to you. That's what happens. So Medicaid won't necessarily take your life insurance policy, but they add the cash value of the policy to whatever you have in your bank. And they say, okay, if you have $50,000 worth of life insurance, cash value, that has a value that you could borrow against, that you could get. And you should get that and use it to pay for your care before you ask us to pay for your care. It is important, and I'm not saying that I agree with it. It's just important to understand it. It is important to understand that Medicaid is a welfare program. And I use that word intentionally, okay? I know it's, nobody's welfare people. We don't like that word, okay? But it's important because this is the only health insurance program that we have in our country that pays for this. Medicare does not pay for it. Health insurance doesn't pay for it. It's a welfare program. So if we are going to avail ourselves of this welfare program, then we have to be impoverished. So these are the rules of that impoverishment.
So take out our cash values of our life insurance now?
No, I don't think so. What I would do is create an irrevocable income only trust and transfer my life insurance policy into it.
Can you change the ownership of your insurance policy? Say to your son.
I would not do that.
I'm just saying. If
You could do it.
something-
And when you do that, you change the ownership policy to your son and you get on your knees and you hope he doesn't get into a car accident and that his dog doesn't bite someone and that he doesn't get into a bankruptcy or have a divorce, because these are the things that happen. So that is, and I sound all vehement and angry when I say that. I don't mean to, it's not you, but I have seen that happen too many times. I have seen folks be penny wise, in my view, penny wise and pound foolish in that. We want to save a couple bucks by avoiding getting it done the proper way. We don't want to pay an attorney, or we want to do it online, or we want to whatever. And we don't want to do it the proper way. So we invent ways that we can just give it to my kid. or rocket lawyer or whatever the thing is that you hear, and because it's too expensive. And then my kid gets into an accident, or I didn't know that my kid had a gambling problem, or one that actually happened in my office. The kid calls and says, this was like 17 years ago, literally. And I'll never forget it because I learned my lesson once. I didn't want to say this in front of my mom and my siblings, but I need to tell you that I hadn't paid child support, and there's a court order. I'm in arrears child support for $47,000. So I can't put my mom's house in my name. Boy, that was a close call. You know, you don't know what's going on behind somebody else's closed doors. You just don't. Whether they're your kids, your family, your brother, your spouse, like you really don't know. Placing assets into the trust protects them from not only Medicaid, but from the creditors of your children, from your own creditors, okay? From accidents that could happen that are totally unforeseeable, for things that maybe are foreseeable that we just don't want to see, from things that people are not telling, all those things. And they protect them for you, and also from, you know, creditors of people that we just don't even know. So it makes sense to me. You can make gifts. You can make, if you're in the habit of making gifts already, like for Christmas, or you've been paying college tuition for all of your grandchildren, or you are in the habit of giving $5,000 for your grandkids' weddings or things like that, don't stop doing that. It's okay. Don't stop doing that because of today. Gifts are an issue when they're made for the purpose of qualifying for Medicaid. Gifts are not an issue if they're made in the normal and ordinary course of your life. If you needed to go into a nursing facility, you would have to show a history of these things. And if you are able to do that, it's okay to keep doing it. Okay? It's all right.
So if you're giving cash, then that you have no proof.
It's not that it's cash, because they can see cash. Okay? Cash disappears. There is always proof that cash went missing too. What I'm saying is, if you have 4 grandchildren and 3 of them got married and you gave 3 of them $5,000, if the 5th one shows up in the 4th one shows up in the 5-year look back period, and I'll be able to show the Department of Social Services, yeah, but look we gave 3 of them $5,000, so we gave the 4th. It was in the normal and ordinary course of life that they did this. They didn't do it for the purpose of qualifying for Medicaid. They did it because this is what they do. Okay.
I have a question about the IRAs.
Yeah.
So, are you saying that, if you're, taking your RMDs, they consider that your income and they don't consider the rest of your IRA, including your spouse's?
Yeah. Yeah. And even if sometimes it happens that people have to go into a facility even when they haven't gotten to the age of 73, so they don't actually technically have a required minimum distribution. So what we can do is carry that RMD forward, even though they're not at 73 yet. We just carry that calculation forward, or I guess backward, and do it even though they're at that younger age, and exempt the principal amount of the retirement account. And this we do with a Roth, and even if it doesn't have that RMD. Yep.
So you're saying that if my husband and I put everything in a trust for our children, like the right way, and then he or I need to have, go into a nursing home, let's say, because one of us is still living, none of that other stuff applies in terms of what I get to keep if he's the one that has to go because it's in a trust, or?
So if we put it into a trust, you still have the Medicaid rules. You still have, like, the community spouse still has their exemption, and the institutionalized spouse has their exemptions. We still can get through the 5-year period. The trust protects everything in addition to that. Okay? So the trust protects everything over that.
Over that?
Yeah.
Okay, so I can keep that money, but my trust, they're still not gonna go back to the principal of everything.
Right. Yes.
Okay.
Yes. If we don't get through 5 years, or if we don't have 5 years, because oftentimes people don't do that, or an emergency happens, and, you know, strokes happen, things happen that are completely out of left field, right? If that happens, then we can do essentially something that is called a gift and a note. So there are still attorneys out there that are relying on something that is referred to as a spousal refusal. And I don't know if anybody here has heard of the spousal refusal, but I would caution you against the spousal refusal. And essentially, I'm bringing it up even though I thought we had kind of abandoned this, but somebody came in yesterday talking about it, so I'm just gonna bring it up. But basically, this is, if you're married and your spouse needs to go into a facility, you can say to the Department of Social Services, I refuse to contribute any of my income or resources to my spouse. Great. And the Department of Social Services cannot hold that against your spouse. They have to open up a Medicaid for your spouse. Which sounds too good to be true, right? Like that's your technique. You're like, okay, I'm not doing it. And they're like, great, we'll just open up Medicaid for your spouse. And they will now open up Medicaid for your spouse. And that is what will happen. And if it sounds too good to be true, like probably is. So now they open up Medicaid for your spouse. But the other thing, and that's like the technique of some attorneys that are out there, like I guess there's one still doing this. And what they do is they turn around and they sue you because you have a spousal support obligation. You have a legal obligation to support your spouse. So if a person, if that is the result, that is a bad result, right? So if anybody tells you something like that, like use your head, right? Like make sure that something makes sense to you, because if all these fears that you have, if somebody just says, oh, well, just say no, like that should ring a bell, right? There is another technique that is called a gift and note technique. This technique is something that does work and essentially can preserve about 1/2 of the assets that you have, even if you don't have 5 years. Okay, so I don't want you to think that there's nothing that can be done. But if you had no time at all, there is a technique that can preserve about 1/2 of your assets, in addition to all of the allowances that you have. So that, if there's a takeaway, that is it. Okay? I think everybody is getting antsy and I have used up too much time. So do you guys, I can go into the gift and note a little bit if you would like me to, or I can stop talking. It's up to you. You can kind of let me know what you would like, or I can stick around for questions, or I can take questions if anybody's got them.
Do you have any kind of a consultation where you can come on?
Yeah.
Sit down and.
Yeah.
What's that like?
So I will do a consultation. If you guys like, I charge a fee of $350 for a consultation. Typically what I will do is, send you a questionnaire that has information regarding your financial information and your sort of demographic information, and sit down for about 1.5 hours or 2 hours and kind of go over everything. I'll give you then a specific recommendation, and then I will give you the specific estimate. It's not an estimate, it's an exact cost of what my recommendation is for you, so you'll know at that moment how much it would be.
I'd like to hear about the gift and note.
Okay.
Of anybody else?
I would.
You want to hear about it?
Yeah.
All right, so here's how it works. So let's say that we total up everything that you have. We make sure that you have that the person who's in the facility has $30,182, that their spouse has $74,820, so they got about $105,000, okay, that together. That in addition to that, they have, let's say, it's gonna be hard for me, is there? Yes.
Chalkboard.
All right, I'm gonna use the chalkboard, so I've gotta look over here, okay? So let's say we've got, in addition to that, we've got, gotta try to make it easy for myself because I'm not real man. Got 100,000, let's say 200. I got $200,000 left, okay? So I'm gonna take 100,000 of my 200, and I'm gonna make a gift. Okay? Now, I know that if I make a gift of $100,000, that there's gonna be a penalty of 8.5 months, okay? Because I already know how the penalties work. So I'm gonna get an 8.5 month penalty. But I also know that I started with 200,000 and I still have $100,000 left. So I take $100,000 penalty or gift, and I'm giving that to like my child, okay? So I have $200,000 over resource. I have $100,000 I got 74,820 for my spouse. Okay, I got 30,182 for my Medicaid applicant, okay? Now I have 200,000 excess. All right, I take $100,000 and make that as my gift, and that results in an 8.5-month penalty, okay? Does that make sense to everybody so far? All right, I take out another 100,000 and I make a note. It's a promissory note. A promissory note is just a loan. It's just a loan document. So over here, I made a $100,000 gift to my son. Over here, I'm making a loan to my daughter. Okay? So there's no penalty associated with a loan because my daughter is gonna pay me back with interest. Okay? So there's a gift and that results in an 8.5-month penalty. But this is a loan to my daughter. She's gonna pay me back. She's gonna pay me back over a term of 8.5 months. Okay? And so she's gonna pay me back over the same time period that the penalty is running from the Department of Social Services for the note, for the penalty, okay? So at the end of the 8.5 months, the penalty will expire from the Department of Social Services and the loan will be paid back. So during this 8.5-month penalty, the loan is paying my nursing home bill. And at the end of the 8.5 months, the penalty will expire and I will have been able to save $100,000. Okay? Does that make sense?
Yes.
I don't understand how you get the person into the nursing home before your loan is paid off, though.
That's a good question, okay? Because the loan, I paid it in a lump sum to my daughter. That's a very astute observation, actually. At the same time, the question is, how did I get into the nursing home before the loan is paid back? Because the whole thing was out of my name at once. Because what you're thinking is, I had too much money, I couldn't apply. But I paid the whole thing out because on day one, I gave my son $100,000 and I gave $100,000 to my daughter, so this whole thing was gone. So I only had this. So I was under-resourced on the day that I applied.
So you didn't have any money.
That's right.
You didn't have anything then.
Right, I had nothing. I had my $30,000, my spouse had this, my son had this, my daughter had this. All I had was $30,000 penalty. And then my daughter gave me payments every month that helped me pay the nursing home. And when I was done paying the nursing home, I was back to having this. My son kept $100,000.
Should do that?
Yep. So that's how we do it.
That's supposing that your daughter will pay the nursing home.
Well, yeah, no, my daughter pays me back, and she has to pay me back because that's a loan. Not a loan.
So the son had $100,000 and the daughter did nothing.
Yeah.
Your spouse goes to nursing, so you call your attorney, whoever takes care of it.
Yeah.
Almost that same deal.
So I would say that's a good question. So the question is, if my spouse is going into a nursing home, I should call my attorney almost that same day. I will call them as soon as I work pretty closely with my clients, right? So I recommend that my clients call me anytime there is a significant change in their family circumstance or in their financial circumstance. So anytime there is a significant change, and I mean, if a person is born, if a person passes away, if they win the lottery, or if there's a bankruptcy, okay? Like if there's an illness, like I want to know about it. Now, I'm not on the phone with people like every week, but I like to check in, right? Like every 5 years. When there's something going on, if there's a diagnosis, I wanna know. If your mom has Parkinson's, I'd like to know about that. You know what I mean? And we kind of stay in touch. I kind of view it like not as close maybe as a financial planner type relationship. I don't want to sit down every 6 months. I don't think it's that important to like be that on top of it. I mean, I think it's that important, but I don't think we have to be like that connected. But I think it should be a regular conversation. This stuff is moving all the time.
Yeah.
And it can really be, it can be helpful and easy, and it can be something that actually gives you great peace to know that it's handled appropriately, or it is something that can really be a monkey wrench in your life, you know, and it is, in my mind, really helpful to know that your ducks are in a row.